Mr. Speaker.
Mr. Speaker.
I call the Honourable Member Simon Bridges.
Honourable, not yet. Well, I was getting confused. The Honourable David Parker was trying to... I thought he knew something I didn't know. Legal aid, Mr. Speaker, is a fundamental part of civilised, as we like to think of it, sophisticated and humane society. And one way I was thinking to think of it is that what it does is it redresses power imbalances so that people who effectively are powerless, who don't have the resources, can nevertheless have a fair day, week, month in court, depending on the complexity of the case against them, and indeed get legal assistance and advice before that, so maybe it doesn't come to that. In criminal law, it's very simple why that would be the case. It's a state that's bringing a case, and someone should have a right to a good defence against the state. Family law, also relatively straightforward some of the time. In civil cases, and family is a breed of civil case, it's perhaps not quite so clear, but even then, I think we would all agree that where someone without the money and resources is being sued or has a legal right, that there should be, to some extent, public monies to pay for them to have their day in court, to take on the powerful who might be raising a case against them. And so, as I say, it's important that we have a good legal aid system in New Zealand. But I don't think that means that we should be lazy about our thinking on legal aid. It is expensive. Costs have been rising very significantly in recent years, and we're led to believe in the Justice Committee were to continue rising, if not exponentially, certainly dramatically over years to come. And so we can't be lazy about our thinking. Dame Margaret Baisley issued a report. That's been picked up on, and this bill, soon to be law, is part of the government's response to her reasonably rigorous report into legal aid in New Zealand, where she found, and I accept we can't tar all lawyers with the same brush, but she found some concerning cases, whether anecdotal or more widespread, in a sense, doesn't matter. And so this bill makes for and begins a process of making for a more efficient legal aid system, and that's got to be good. I agreed with what Honourable David Parker, who's next to speak, said yesterday in the committee stages, where I think he may have been slightly different than this, but talked about a continuum with sort of justice versus efficiency. And efficiency is still very important. I mean, you can have $1 million drink driving case probably that takes weeks, but the cost of that would be prohibitive and not worth it. And so some regard has to be had for efficiency. But the other thing that this bill does is it allows for competence and competence testing, a quality assurance framework where practitioners who get legal aid will need to demonstrate competency. And that, I think, is very important. It's been said to me before, and it's true, someone could get an LLB from any of the, I think, numerous universities in New Zealand, probably too many, that offer law degrees in this country. They can set up shop in anywhere in New Zealand. They, of course, got to do the professional requirements. But once they have done that, they never, ever again in New Zealand need to do anything more to upskill or to train or to better themselves as a lawyer. And I'm sure David Parker, Chester Borrows and I probably actually were diligent when we were practitioners and going along to NZLS courses, updating us on the new law, or I remember going to one on the Evidence Act that the past Parliament. They were expensive, actually, these courses, about $700-800 sometimes a pop. But the point is, they did do a good muffin and scone, though, but that's another point. But the point is, some would be diligent and go to these courses and would upskill, but actually there's no requirement to do that. Now, where you are getting public money to defend or to pursue a case, there are competency requirements. I think that's fair enough. It's a quid pro quo. It's a to change the status quo, says my poetic friend and colleague Cam Calder. So that's that. I just also make some final concluding remarks again about some things that David Parker said yesterday and Simon Power, the Minister, said yesterday, where we have been embarking on criminal law reform, family law reform is to come, and perhaps even civil, broader law reform. Of course, how we fund civil cases is I don't recall Jacinda doing LLB, but that's okay. That's not a problem. You can go to night school, I think, through Waikato, Jacinda. And then maybe I'll quote you in legal reform bills. Anyway, I'm getting off course. Just finally, civil aid law, civil reform is to come. There's a number of things we can consider there. CFAs, conditional fee arrangements, agreements is something they do in the UK and they're now revisiting. We may look at those sort of things, I think, in the future in this country, but they're not without their pitfalls. This bill is a very good plank of progress in legal aid reform in this country, and Simon Power and the Justice Committee that I was on, or am on, is to be commended for our work.
Honourable David Parker.
Speaker, I want to speak in support of the Legal Service.